Hello everyone, welcome to the data protection series. My name is Lazarus Carlo and I am a data protection and technology lawyer in Nigeria, and I regularly provide actionable insights on compliance with data protection in Nigeria. If this is your first time joining, please subscribe, like and turn on your notifications so you don't miss any of my episodes. In today's episode, we'll be talking about the legal basis for complying with data protection law in Nigeria. You remember in the last episode, if you have not watched the last episode, please kindly go and watch it. In the last episode, we talked about that for processing activities to be lawful, it has to meet at least one of the grounds for processing. And today, we'll be talking about the 6 lawful grounds recognized under the Nigeria Data Protection Act for processing personal data of individuals in Nigeria. Please note that if you are handling any person's personal information and you don't have any of these grounds, your activity, your processing activity will be wrongful and unlawful, and you'll be in violation of the law. So the lawful grounds for processing personal data are: number 1, consent. This means that when your organization or yourself, you are handling or processing any person's personal information, that person must have given you consent to do that. And consent in this context means that the data subject, the person whose personal data you are processing, that person must have given you the consent to proceed in handling that personal data. And the person can only give you this consent if you have provided the person information relating to why you are processing the personal data, how you want to process it. So the person must be fully informed before giving you consent. So consent that is not based on full disclosure of information is not a valid consent. And another thing about consent is that you must provide a mechanism for the individual to easily withdraw consent. So in as much as the person is giving you consent, the person has a right to withdraw consent. So in conclusion on this subject, consent is one of the primary or legal basis for processing personal data, and it must be informed, and the data subject must freely give you that consent without any force or compulsion. So the second lawful basis is contract or performance of a contract. So if you need personal information of someone in order to fulfill your contractual obligation to that person, or in order to enter into contract with that person, then your processing activity is lawful. Let me give you an example. In the context of employment law, for instance, when applicants for job apply for positions or vacancies in organizations, they usually submit their CV, and this CV contains their personal information, their name, the schools they attended, their grades and all that. All this information in the CV are their personal data. But for the employer to engage the applicant, the employer needs to have this personal data contained in the CV. So this is the processing of the person's personal information for the purpose of entering into a contract of employment. So in that case, the processing of personal data is in order. And the third lawful basis for processing personal data we'll be talking about today is legal obligation. What does this mean? If the law, any law in Nigeria, requires you to comply with any obligation, requires you to do something, and in doing that thing, you need to use someone's personal information, you need to disclose people's personal data, then your disclosure of personal data in compliance with that law is in order. You don't need the person's consent to do that, and that processing activity is lawful. Let me give you an example. Under the tax law, companies are required to pay personal income tax of their employees. So at the end of each month, you deduct an employee's personal income tax and pay it to the appropriate state revenue authority. So for you to pay that tax, you must disclose to the revenue authority that you are paying this amount of money on behalf of this employee who earns this X amount of money. So that disclosure of personal information to the tax authority is lawful, because the personal income tax imposes an obligation on companies to remit personal income taxes on behalf of employees. So the next lawful basis we'll be talking about today is vital interest. What does vital interest mean? Vital interest is typically you don't want to rely on this lawful basis, because it rarely happens, because it only happens in circumstances where the data subject is incapable of giving you consent, and you need that person, you need to process the data subject's personal information to protect the data subject. I will give you an example. So for example, there is an accident and someone has been rushed to a hospital and the person is unconscious, but you need to reach out to the person's relatives. You need to do tests on this person to know how you treat this person. So reaching out to having access to the person's phone, which is processing his or her personal information, or carrying out tests, again, which is processing his or her personal information, is valid, because this person at this time cannot give you consent, and you need to do these things to save this person. So it is in these limited circumstances that vital interest is usually relied upon as the lawful basis for processing. Then the next one we'll be talking about is public interest. So if you are carrying out activities that requires you to process people's personal data in the public interest, or in discharging your obligations or your functions in your official capacity in the public interest, then your activities, your processing of personal data will be in compliance with the law. I'll give you an example. So there are a number of government authorities and agencies that have been established all over the country, and for them to properly function, for example, the land registry. For the land registry to properly function, if you are buying a land, you need to register that land. And for you to register, you have to disclose your name. You have to tell them how much you have bought the land, where the land is located, the size of the land. These are information that relate to you, but the government authority, that's the land registry in this case, cannot properly function unless you provide this personal information to them. So the last lawful basis we'll be talking about, and which most organizations usually rely on, is legitimate interest. The data controllers or your organization will usually rely on lawful basis to protect its interest. For example, to prevent fraud within an organization. So you may put in processes in place that collect people's information for the purpose of preventing fraud. And again, you may rely on this grant to communicate to your customers that you have new products or new service. However, before you can legitimately rely on these lawful grounds of processing, you must carry out what is known as legitimate interest assessment. And this assessment is trying to balance your interest. So you have an interest, for example, to prevent fraud within your organization. That interest you want to protect, you have to balance it against the interest and the rights and freedom of the data subjects. And when the interest, rights or freedom of data subjects supersedes or prevails, overrides your interest, then you cannot rely on legitimate interest. So these are the 6 lawful grounds for processing personal data. And in your processing activities, in all you are doing in handling people's information, please always try to ensure that you have at least one of these lawful grounds, because if you do not have these lawful grounds, your actions and your processing activities will be in violation of the law. This brings us to the end of this episode. I hope you enjoyed it, and if you have not subscribed to this channel, please do, as I regularly provide actionable insights on how to comply with data protection law in Nigeria. See you on the next episode.